Yes, ready. Start. In the present case, the respondent in the writ petition had raised a specific plea of delay, as a bar to grant relief to the petitioners. Full stop. In our view, it was perhaps necessary for the court to have specifically dealt with this issue. Full stop. It is now well settled that a person who seeks the intervention of the High Court under Article 226, should give a satisfactory explanation of his failure to assert his claim at an earlier date. Full stop. The excuse for procrastination should find a place in the petition filed before the court, and the facts relied upon by him should be set out clearly in the body of the petition. Full stop. An excuse that he was hesitating his claims before authorities by making repeated representations would not be satisfactory explanation for condoning the inordinate delay in approaching the court. Full stop. If a litigant runs after a remedy not provided in the state, it cannot be a satisfactory explanation for condoning the delay in approaching the court. Full stop. Para. On this issue, we have heard the learned counsel for the parties in great detail, since the immovable property right of the parties are involved. Full stop. In our considered view, there is no explanation, much less satisfactory explanation offered by the respondent in approaching the writ court after an inordinate delay of nearly 15 years from the date of the notification issued under the Evacuee Property Act. Full stop. For the delay from 1952 to 1955, the contesting respondent would only submit that they were not aware of the notification issued under the Evacuee Property Act, since no notice was served on them, though a public notice was issued by the authorities under the Evacuee Property Act. Full stop. While explaining the delay of nearly 11 years from 1955 to 1956, they contended they were in a possession of a property and they were making representation before the authorities and the Evacuee Property Act for redressal of their grievance. Full stop. The delay after order were passed by the settlement commissioner in the year 1983 till the writ petition was filed in the year 1990, it is explained that they had moved the state government's suo motu to revise the order passed by the chief settlement commissioner, and since the state government returned their request. Full stop. They had approached the High Court to issue directions to the state government to issue appropriate direction. Full stop. Para. In our considered view, there was inordinate delay in approaching the authorities for redressal of their grievances. Full stop. As rightly contended by Sri Mukund, even when they approached the authorities, they were claiming wrong reliefs or incomplete reliefs. Even they filed the writ petition in the year 1990, they did not choose to question the correctness of the notification, but was questioned by way of a filing an amendment application in the year 1998. Full stop. There is some merit in the submission made by the learned counsel for the contesting respondent that the petitioner had not even offered any satisfactory explanation in approaching the court nearly after 3 decades from the date of notification issued under the Evacuee Property Act. Stop.